We're joined now by Mpumelelo Zikalala, legal practitioner of Zikalala Attorneys, to further the conversation. A very good evening to you, and thank you so much for speaking to us. Perhaps we should start with the salient points of her bail application. Do you believe it's compelling, just given the fact that it is, the onus is on the defense to prove that she ought to be given bail, but particularly this argument that she had been kidnapped? Does it present a case for those who have to make the decision to chew on and believe that this is somebody who's really being held against the spirit of justice?
Good evening to you and also to the viewers. Well, I think we should remind ourselves that the purpose of bail or the bail application is to say, if we release you today, are you going to come back on another date that we are going to set for you? Are you a person who's a flight risk, or when you have been released previously on bail, did you behave in a manner which is suspicious or did not follow the conditions that were given to you by the court? That's the only thing which is there. In fact, there are three questions which are looked at. Are you a danger to the public, or are you someone who is prone to public violence? Are you a person who is going to evade their trial? Are you a person who is going to interfere with the witnesses and even with the evidence? And looking at the whole scheme of things, is the granting of bail to you could be something which is maybe looked at as being injustice in any other individuals? If you're able to answer those questions within any years, then the chances of getting a bail application are usually slim. But in this case, we're dealing with a person who is a first offender, no previous conditions which are attached to her. There are no other pending cases that are there. There's a person that says, I have family ties within South Africa. My family is there, my work is there. And if you offer any money which is required, I'll be able to provide it. But most importantly, remember to protect my constitutional right that says I'm innocent up until proven guilty. These particular proceedings are not to determine the merits of the matter. So I may have stated my defense, which is going to come at a later stage, but I was simply doing it to show this court that I have a bona fide defense that is there. It will be further explained at a later stage when the time is right and when I can lead evidence pertaining to it. But for now, I want you to understand this. I'm innocent, and I want my rights to be protected at all times. And the only way in which you're going to do that, because you can't repair my time if I'm found not guilty at a later stage, is to allow me to be released on bail. And I'll make sure that I'll stick to whatever conditions which are going to be attached to me.
I want to concentrate on the issue of her being a flight risk. The defense argued that this can't be the case given the fact that her documentation, traveling documents, had been confiscated. The argument that was used that she has young children and, as you mentioned, family ties, but the state arguing that she initially had escaped with those young children left behind, the family ties being a husband whom she had not shown any marital commitment to in terms of her actions. How much are these going to be weighed in on in the consideration of whether or not she is a flight risk?
They are looked at, or there's some type of weight or considerable weight which is attached to them, but not that much. Reason being, the circumstances in which she engaged in all these things is still under scrutiny. So the determination of the merits of all the allegations which have been leveled against her is going to be determined at a later stage. And there might as well be a valid defense as to why she engaged in that particular manner. And she was very, I would say, clever in terms of attaching some type of explanation to her affidavit in terms of saying, you must know that I did not act in this particular manner willingly. It's not through my willful participation in the process in which I find myself here. There's been some coercion that is there. I've been fearing for my life. I'll elaborate on that at a later stage. So don't attach me or don't try me on that, or don't place me on trial for something which evidence has not been led earlier. But another process which she was trying to employ the court to do was to say, you have the power as the court to employ preventative measures that are going to enable that I'm able to enjoy my freedom, meanwhile, while you are able to investigate whatever that you need to investigate. For example, you can say that I must report at my local police station every single day within the hours of 8 a.m. and maybe 5 p.m. You must say that I must surrender even all the passports that I have and make sure that I do not remove myself from the jurisdiction, which is the Ministerial Court district of where I'm going to be living. If I do that, my bail conditions would have been broken, and I'm going to be forced to spend the rest of the days up until my matter is done and does it behind bars. So there are measures that can be employed at the end of the day. What we must remember in this particular case is this: we are not yet at the trial stage. So whatever that you are looking for, we are not looking at whether something has taken place or not. We're simply saying, what is the likelihood of that particular process taking place? If there is a likelihood, what preventative measures can you then employ in order to prevent that likelihood from taking place? And if there are preventative measures, let's rather do that. What are we trying to run away from? We're trying to run away from a situation when a person has stayed behind bars for almost 6 to 5 months, as it's been done now. If they are found guilty, we can't repay them their time. We can't do that. So a best way to do it is to say, let's level the playing fields. I'll make sure that you're able to temporarily enjoy your freedom while we still continue with the investigation from the side of the prosecution. And when the time is right and when the evidence has been gathered, you will come back to court and be able to hear the allegations that have been leveled against you.
You mentioned earlier on the strategy she employed, where she hinted at her inability to make decisions freely, that her rights were curtailed because she was forced out of the country. I'm just wondering, when the decision is made and weighing on the veracity of these claims, which the state countered with, she had been evading arrest for a period of 11 months, to which then the defense argued, but there was no charge, there was no arrest warrant. So if one is trying to prevent prejudice in making up their minds on whether or not she is entitled to bail or not, where does all of this information begin and end in trying to determine the correctness of the decision?
It's part and parcel of the questions which are asked, mainly three, of saying that what's the gravity of the charges that you are facing? What's the gravity of the sentence that you might get or the sanction that you might get if you're indeed found guilty? And last, which is almost the same throughout Section 60 of the Criminal Procedure Act, is to say what else in the opinion of your court is something that would be deemed to be very important. Now, because we're not dealing with the trial, there might be a very good reason why she engaged in the manner that she engaged, or there might not be a reason at all. But what matters the most is to say, out of the circumstances and the facts that you have in front of you as a presiding officer, do you have a candidate that can be released on bail? How do you determine that? Are there preventative measures that you can then be able to employ? If there is, then let them go. If you don't have a track record of a person that has misbehaved previously, have been given instruction by the court and did not follow those particular instructions, then you have no reason of saying to that individual, I'm not going to let you go. What you should run away from, which is what especially this magistrate court in this particular matter has been doing, don't engage in a mini trial or in a pre-trial exercise and find these individuals guilty before evidence is laid before them. In fact, if you look at a number of people that have applied for bail within this magistrate court, a number of them, when they go to the High Court, bail is granted, which proves to say maybe the manner in which the presiding officer was looking into the instances of bail was a bit on a harsher level. When it comes to bail, the innocence and guilt of the individual, yes, it is important, but not that important because there's no evidence in front of you which is there. The only thing which is looked at, is it in the interest of justice that you are so released? If there's evidence against you, yes, fair and good, it's going to work at a later stage on a much better sense. The evidence or the defense that you provided to me, yes, I'm going to accept it for now, but I'm not the one who's going to evaluate the veracity of that evidence. Another presiding officer is going to do so. For now, I'm simply going to grant you bail if there's no indication to me that you're going to evade trial.
And I want to point at something that was raised, although it was more in the court of public opinion, the interaction between Thabo Bester and Nandipha Magudumana. You know, the intimacy that came across and the questions that arose about her mental state, psychologists even weighing in on the ingenuity of the escape plan, even though there might be certain bail limitations that are is there somebody with a mental capacity, and it relates to the flight risk, that would go even beyond what has already occurred. And as I say, this is trying to do so without prejudice. how thin a line is that in trying to determine whether that should also play a role by the presiding officers to think about that? Because the seriousness of the charges that she also faces, fraud allegations of up to the tune of 20 million rand in other cases, but the issue of violating a body, corruption, arson, etc., etc.
Now, you see, the issue of being a flat risk can't be ignored. And we are not saying in this instance that the court should ignore it. The court acknowledges it and finds the problem or the potential that can be engaged in a person being a flat risk. But the most important question then is, are you able to employ preventative measures which are going to prevent this person from engaging in this particular factor or engaging in these particular processes which have been identified? So if they do engage in those, then the bail conditions would have been broken and the person would be forced to spend the rest of the days behind bars. Now, in court, the only time in which certain gestures and information would matter is when a person goes and says, I'm now under oath. You can now start applying those scrutiny eyes and scrutiny exercises to me and the evidence in which I'm going to pose to you. Other than that, before the proceedings start, the way in which I've been interacting with other co-accused, the manner in which I've been behaving, cannot be taken or cannot be adduced to being evidence that can be evaluated at a later stage to determine either my innocence or guilt or to determine whether I'm eligible or I'm a perfect candidate to be released on bail. So the manner in which they've interacted with each other is not necessarily something which is going to be considered by the court. And in fact, it ought not to be considered by the court because it was something which was not done under oath and it can't be part and parcel of the evaluation process. What it does, though, from a social level is that even though it may create a perception to us as members of the public of saying, wait a minute, a person who is hurt, a person who is fearful of their life will not behave in such a manner. But the adverse or maybe the counter-argument would be, look at couples which are being abused on a regular basis, on a daily basis. You may find that during the day they act as a perfect lovey-dovey couple. However, at night, things change because one of the parties will turn into a monster. But they wake up the following day and even want to be with them. You have instances in which couples end up in hospital, for example, and the very next day they wake up and say, "What? We do not want to open a case. I still love my partner. We can work things out. In fact, it was my fault." So you can't take away those mind problems or issues with certain things that have to be taken into account at a later stage. I would say on my side, let's wait up until the time to present that evidence comes in. So that's when we'll be able to evaluate, was there fear? Was there fear which was threatening at all times as she engaged in these particular factors? What's the current of the fear as we speak? And only on that basis we will then be able to determine and say, we have someone who is genuinely fearful of Mr. Bester, or if someone who is creating a perception of being fearful, and that particular perception must not be trusted.
Well, thank you very much for your time and insights. It's also playing out in public discourse and all kinds of theories, Munchausen effect or Stockholm syndrome, some have suggested. So it'll be very interesting to see what the law has to say about this tomorrow. Mpumelelo Zikalala, thank you for your time of Zikalala Attorneys.